Have you ever wondered how you, an MTN subscriber, are able to place across a call to your friend who is a Glo subscriber, and you both have a seamless and each-free conversation, or in some situations you place a call and it doesn't even go through? Good day, esteemed viewers. My name is Tijesunimi Onawumi, a 400-level student of Ajayi Crowther University and an undergraduate intern at HARLEM Solicitors. Today, I'll be delivering to you a lecture on the topic Interconnectivity of Telecommunication Networks in Nigeria. At the end of this lecture, you'll be able to understand the concept of interconnection as well as the regulations and guidelines and the relevant guidelines and regulations, as well as the registration and approval of an interconnection agreement. You might be wondering, what is interconnectivity? The word interconnectivity can be used interchangeably with the word interconnection, as they both imply the same thing. Therefore, it is defined by Section 157 of the NCA 2003, that is the Nigerian Communications Act of 2003, as a physical and logical linking and connection of communication systems used or operated by the same or different operators in order to convey messages to and from respective systems for the provision of services. It is also defined by the World Trade Organization as a linking with suppliers providing public telecommunication transport services in order to allow the users of one supplier to communicate with the users of another supplier and to have access to the services provided by another supplier, where specific commitments are undertaken. Now, there are a wide range of services that are provided by virtue of interconnectivity. They can be classified into principal services and ancillary services. The principal services include call termination or call origination, mobile termination, and transit services. Then the ancillary services include access to directory services, access to emergency services, as well as billing services. However, for the purpose of this lecture, I'll be focusing on the concept of interconnection using NCA 2003 as a stepping stone, as well as other relevant guidelines and regulations under the NCA. It is an established fact that the Nigerian Communications Commission is the internationally recognized regulatory authority for the telecoms industry in Nigeria. Therefore, in exercise of its regulatory authorities stipulated in Section 99 of the NCA 2003, the NCA established the Telecommunication Networks Interconnection Regulation and the Guidelines on Interconnection of Telecommunication Networks in 2003. However, both the regulation and the guidelines were repealed by the NCC in August 2007, and they were replaced by the Telecommunication Networks Interconnection Regulations 2007, and other relevant guidelines were put in place, and they include the guidelines on technical standards for interconnectivity of telecommunication networks, the guidelines on the procedure for granting approval to disconnect a telecommunications operator 2012, hereinafter referred to as the 2012 guidelines, the guidelines on the international gateway access and voice over internet protocol. Now, I want you to know that the reason why you are able to place that call is because there has already been an interconnection between both your subscribers. Now, before there can be an interconnection, there must first have been an interconnection agreement. And to every agreement, there are rights and obligations that are stipulated for both parties. Section 96 then provides, Section 96 of the NCA 2003 then provides the rights of an operator to request interconnection from another operator. It is then corroborated by Regulation 1 Sub 1 of the 2007 regulations that stipulates that upon receipt of request for interconnection, the requested operator has an obligation to interconnect the system or network with that of the requesting operator. However, there are instances whereby the NCC may limit such an obligation, which is provided under Regulation 1 Sub 5 of the 2007 regulations. Such instances include where an interconnection agreement is prohibited by law, where the license of an interconnection of an operator does not authorize the service for which interconnection is being requested, where interconnection is impossible due to technical specifications, where the interconnection could endanger life or safety, or result in injury to harm or the property of a requested operator, or could hinder the quality of service provided by an operator. Now, where the rights and obligations of the parties have been established, they need to pay attention to Regulation 5 Sub 2 of the 2007 regulations, which requires an operator who is requesting for interconnection to notify the NCC in writing of its request for interconnection. It is then added that in Regulation 5 Sub 3 that within 14 days of the receipt of request for interconnection, the requested operator has to inform the other operator of whether it can provide the form of interconnection that is being requested and whether it can provide that form of interconnection within the requested time frame. Now, where the parties have been able to meet this, they have to pay attention also to Section 97 of the NCA 2003, which requires that all interconnection agreements shall be in writing and shall comply with the NCA and any other relevant guidelines and regulations under the NCA. Now, they must also comply with the principles of neutrality, non-discrimination, access to information, universal coverage, fair competition, equality of access, as well as equal terms and conditions. Now, where they have been able to meet all of these requirements, they then have to proceed on to the registration and approval of such an agreement. It is then provided in Section 98, Sub 1 of the NCA 2003 and Regulation 3, Sub 5 of the 2007 regulations that every interconnection agreement shall be registered with the NCC within 30 days from the date of the execution of such an agreement. It is then added that the NCC may evaluate the terms and conditions of such an agreement, but has to notify the parties within 10 days from the date of the registration. Now, the NCC, during that period, is not required to complete such an evaluation within 6 weeks from the date of informing the parties that an evaluation will take place. It is now allowed for such parties to give comments or additions to the terms and conditions that the NCC finds inconsistent with the NCA or any other relevant guidelines or regulations under the NCA. Now, where an interconnection agreement has been successfully registered and approved by the NCC, we can then say that there is an interconnection between both networks. But I would like to call your attention to the fact that there are times where an operator providing interconnection could decide to terminate an interconnection agreement. And it is provided for in Regulation 4 Sub 6 of the 2007 regulations, which requires such an operator to notify the other operator with a 6-month written notice, specifying the reasons for terminating such an agreement. It is also required, however, but in situations whereby the terms and conditions have been breached by an operator, the operator providing interconnection has to notify the other operator with a 3-month written notice, specifying such reasons for terminating the agreement and giving the other party a space to remedy such a breach. However, failure of such an operator to do so within the required period would then authorize the operator requesting for disconnection to terminate the agreement without further notice. However, such an operator must pay attention to Section 97 Section 100 of the NCA 2003, which requires that an operator who desires to disconnect must first gain a prior approval of the NCC and must file a disconnection Form 1 to the NCC according to paragraph 3 sub 12 of the 3 sub 2 of the 2012 guidelines. Now, I want you to also know that the NCC seeks to protect the interests of both telecom operators and subscribers, which is why there is an existence of partial disconnection, which is provided for in Regulation 17 sub 4 of the 2007 regulations, which states that the NCC may authorize the operator who requested for a disconnection to partially disconnect the other operator. Partial disconnection limits only outbound calls from the party who was disconnected to the party who requested for disconnection. For example, where Airtel partially disconnects Glo for the reason of indebtedness of interconnection rate, Glo subscribers would not be able to place calls across to Airtel subscribers, but Airtel subscribers will be able to place calls to Glo subscribers. That might even be the reason why you are not able to place that call. Now, I want you to know that interconnection is very, very important in Nigeria, and its importance cannot be overemphasized, as interconnection is both profit telecom operators as well as subscribers. I hope I've been able to make you understand the concept of interconnection and its legal framework. For more information, visit our website on www.harlemsolicitors.com. Thank you.